The hearing is still underway for Chad Doerman as his defense pushes to get his confession thrown out of the case. His defense says Doerman clearly asked for a lawyer during police questioning, but instead of police stopping their interrogations, they continued. Prosecutors say they have ample evidence to dispute that claim. So we want to get you back into court now. On the stand is Detective Michael Ross. He led the investigation. Let's get you back into court.
This is Dad. What did he say about Ruby Franklin?
He said that she was in the CIA, and I said, well, is she a lawyer in the CIA? And he said, she's in the CIA. So neither name that he gave me were even close to lawyers.
And after that, so you were able to confirm that neither Keith Doerman nor Ruby Franklin were lawyers, and that he was aware they were not lawyers.
Correct.
And so once you confirmed that neither Keith Doerman or Ruby Franklin were lawyers, what did the defendant do?
He changes the conversation and starts talking to me about whether he knew me or didn't know me. He changes the conversation. We're talking about lawyers and who I can call, and he completely changes the subject on me to, what I had talked about earlier about knowing him from 2015.
So when he changes the context of the conversation, was that in response to a question you had asked him?
No.
So he just says something along the lines of, I don't think I've ever met you before.
Yeah, he just continues talking about something unrelated to the lawyer issue that I was trying to clarify.
So did he ever clarify for you?
No.
So when he changed the conversation subject, what did you think at that point?
I thought that he was playing games with me and trying to control the interview.
So can you describe the defendant's demeanor as you then continued the interview?
Yes, it continued the same. His demeanor continued to be the same. When I would ask questions that were unrelated to what had happened that day, he knew the answers right away and had lots of details and could remember things. When I asked him about the tough questions about did you shoot your sons, the things that really showed that he had some culpability in that whole situation, he didn't know, and he struggled to answer, and he would rock back and forth in his chair and just had extreme anxiety about those tough questions.
So was there a very different manner in which he would answer you depending on the topic of the question?
Yes, if it was unrelated to what happened that day, it was very easy for him to answer, and it was very difficult if it was about what happened that day.
And as the interview continued at approximately 1 hour, 35 minutes, 50 seconds into the interview, did the defendant make another reference to a lawyer?
He did. The conversation was about Laura, his wife. We were talking about Laura, and I was asking him questions about Laura. And then he, again, interrupts me and says, who's the lawyer? And at the time, I thought that he said, who's Laura? Because we were talking about Laura. So I looked at him and I said, who's Laura? And he corrected me. He said, the lawyer.
So when he corrected you, he just said, the lawyer?
Yeah, he said, the lawyer.
Did he correct you in any way on the question, who is the lawyer?
No, I said, who's Laura? And he said, the lawyer.
Okay. And did that mean anything to you at that point?
No, I was confused what he was talking about. I was still trying to figure out why we're talking about Laura. Now he's saying, who's the lawyer? So I said, I don't know. You tell me.
And what was his response?
He just kind of went, like he didn't know either or didn't care.
And at any point during the interview, did the defendant deny shooting his sons that day?
Yes, multiple times throughout the entire interview till the very end.
And was there a point during the interview in which the defendant was taken to use the restroom?
Yes. He had made some comments that he believed his wife Laura had poisoned him, and I offered a urine test, which he consented to. And
so did you escort him to the restroom, or did a uniformed deputy escort him?
No, a uniformed Deputy Greer escorted him to the restroom for that urine test.
And as a uniformed deputy, Deputy Greer would have had a body-worn camera, correct?
He was in uniform and he would have had a body camera, but because he was going to the bathroom for obvious reasons, if there wasn't, any type of recording where he would have been exposed or anything like that.
And to your knowledge, did Deputy Greer ask any questions during that trip to and from the restroom?
He did not.
And did you?
I did not.
Were there any other points during the course of the interview that the defendant was left alone in the interview room?
Yes, there were times where I left the interview room where he would be in there with Detective Green. There was times where Detective Green left the interview room and we would be in there alone together. And then there was also a time where we both left the interview room and Mr. Doerman was in there by himself.
And what, if anything?
All right, we'll step aside, take a break here. We'll have more from that courtroom in Ohio when we come back. Keep it here on Court TV.
Tonight on Closing Arguments, we're in a verdict watch in the case against Adam Montgomery. The New Hampshire father is accused of murdering his missing 5-year-old daughter, Harmony. Our legal experts break down key moments from the trial as the jury deliberates. Plus, it was a movie set shooting that ended in tragedy. Now the film's armorer is charged with involuntary manslaughter. We'll take you to New Mexico as this trial gets underway.
Closing Arguments tonight at 8/7 Central, only on Court TV. Or 5/8.
All right, folks, welcome back to Court TV Live. I'm Michael Ayala. Before we go back to court in Ohio, let me bring in my guests. Joining us to discuss, trial attorney Krista Ramey and L.A. County Deputy Public Defender Philip Dubé is with us as well. Thank you both for joining me here on the program. And Krista, I'll start with you because I want to get both your opinions on this one. I can tell you, as a defense attorney, when I saw the questioning and I saw the words being used by this defendant, my red flags went right up, Krista. I want to know what you think about this one.
I did too. I think that you're hearing it. Well, it wasn't clear and unequivocal ask for a lawyer, but was it? I think that it probably. I think that's a very good argument that he very clearly asked for a lawyer. He says that. Who's my lawyer? Who's the lawyer? He doesn't have to have a lawyer. He doesn't have to have a lawyer on retainer. When he gave his dad's information, that could have been for him to speak to his father, so he could have gotten a name for a lawyer. The fact is that he did request a lawyer. And at that point, all questioning has to stop. You can't continue to question. So you stop questioning and you figure out what's going on. Does he really want a lawyer? Because he had previously waived his rights. So, you can really kind of maybe nail him down a little bit because it sounds like he might have been a little off. His mental state at this point might be a little questionable. He wasn't making a lot of sense. So I can understand maybe trying to drill down on it. But you drill down on the point of, do you actually want a lawyer? And if you are unclear about it, I think as a law enforcement officer, you have to stop the questioning until you are clear about it.
And Philip, I think that's what makes this hearing so important, because we know at this point, this guy did something that's reprehensible. There's no defending it. But his rights have to be protected. I mean, he's exactly the type of defendant that needs to be protected. And officers, police, those in power need to understand that if someone mentions a lawyer, the questioning has to stop. They have rights just like everyone else. And that's why this is so important, even with these horrible facts.
Of course it is. And this is exactly why a lot of states have passed their own laws requiring all police interrogation interviews to either be videotaped or at a minimum audio recorded, so that it's not a fight between a defendant and law enforcement. The cops can take the stand at a Miranda hearing and just simply say that the defendant was advised of his rights, that he understood his rights, and that he waived his rights. The court needs to actually hear all that. There should be something in evidence to corroborate it. Otherwise, you're stuck. Now, I must say, though, that the law is pretty clear throughout the nation. Edwards versus Arizona, and of course, we have the Minnick case out of Mississippi that says essentially that once a defendant invokes his right to counsel, in other words, says, I want a lawyer, all interrogation by the police must stop. The problem with a lot of defendants is they don't affirmatively ask for a lawyer. They'll say something odd like, where's my lawyer? And the response could be, I don't know, maybe he or she's in court, or maybe he or she is on vacation. Or do you happen to know the status of my attorney? Well, no, how would I know? As opposed to, I want a lawyer. Once the affirmative demand, that invocation is made, those are the legal constitutional buzzwords for the cops, and they know they're dead in the water. And short of getting him his lawyer or the defendant himself reinitiating communication with the police, they got to stop.
Well, let me ask you this.
And the remedy is exclusion.
Yeah, absolutely. At least everything up until the point where he asked for a lawyer would be allowed in, but anything after that is a problem. But Krista, you talked about it earlier. He basically says something to the effect of, give me a couple of days, let me talk to a lawyer so I can get my answers right. Something along that line. Does that rise to the level? Philip makes a good point. You can make these odd statements that can be or are open to misinterpretation, but does this rise to the level?
That statement says to me, I want to talk to a lawyer. And so if he wants to talk to a lawyer, you better get him that lawyer if he can't afford one. Because one will be appointed to him. We know our Miranda rights. It is, to Philip's point, I think Philip makes a very good point. That's why it's important that these interrogations are recorded, whether it's through body, the Miranda rights are given with a peace officer wearing a body-worn camera or in an interrogation room, because when you have someone who maybe isn't as clear, I don't know that people really speak the way that courts would like us to speak. I want a lawyer. So I think that that's the problem here, is that he didn't use those exact words.
Yeah, that gives them that little window that I think is what the state is arguing as well. All right, stand by, guys. I do want to take folks back to court now. Still on the stand, Detective Michael Ross. He did the interview, this interview that the defense is trying to get thrown out. Let's get back into court for more of his direct examination.
Again, it continues recording audio and video. He said, almost like under his breath, like a whisper, she let me do. Another time, it looked like he was checking the back of his shirt for blood. There was another point where he's looking around and he says, "Where's the cameras? Where's the cameras?" So he was looking for cameras. And then that picture that I talked about earlier was still on the table. There was another point when he was in there by himself where he looked at it and kind of flicked it away from himself, like in disgust.
And all of those things occurred while he was alone in the interview room?
Yes.
Now, in between those times where he was left alone, did you come back in and pick up the interview again?
Yes.
And as the interview continued, did he continue to refuse to talk about what had actually happened that day?
Yes, he said that he didn't remember, he didn't know, he didn't understand why he was there.
But did he provide you with other information that made you believe he was aware of what was going on and what had happened that day?
Yes, because as the interview went on, it was like a slow drip of information. I would gain a little bit, and then we would keep talking, and then I would gain a little bit more information. He had lots of details about a lot other things, other aspects of his life, but again, couldn't remember what happened that day.
And what kind of details specifically stick out to you that he was able to provide you during the course of the interview?
Things like we wanted his safe combination so we could check the safe, and he knew that, the safe combination. He knew a lot of details about who had access to that safe and who didn't. He had extensive details about when the last time Laura shot his gun, which was about 10 years ago, and who else was shooting the guns, and a lot of details about things like that.
And so again, did the trend continue that when you began to talk about his culpability, he lost all recognition of what was going on, but when you were talking about other details, he was fine answering your questions?
Yes.
Now, the interview, when that records at your department, it cannot record more than like 2 hours.
All right, we'll take a break here. When we come back, the defense gets their opportunity to cross-examine the detective. Keep it here on Court TV. right, let's get back to that courtroom in Ohio where Chad Doerman's defense team is trying to get a confession that he gave to police that he executed his own sons thrown out. They're claiming, of course, that he wasn't read his Miranda rights properly and that he asked for a lawyer, but the questioning continued. On the stand is the detective who did that interview, that questioning, that interrogation, Detective Michael Ross. He's on cross-examination now, and Doerman's attorneys is asking him about the reading of those Miranda rights. Let's get back into court.
All right, now you discussed briefly the Miranda rights. You did not read all the Miranda rights on State's Exhibit 3, did you? On your card?
Word for word, no.
Well, you left out some pretty important parts, didn't you?
No, I think I covered the important parts, and he understood that he had the right to an attorney, and he had the right to have an attorney if he could not afford one.
Okay.
Those are the important parts, and he understood that.
Well, you left out the part as far as that right to an attorney is. You did say you have the right to talk to a lawyer for advice before we ask you any questions. But the part of the card goes on to say, and to have a lawyer with you during questioning. You did not read that part, did you?
No.
Why not?
That kind of is redundant. It kind of repeats itself, and it's not the important part for me.
Well,
Sorry, go ahead.
I'm sorry. One's talking about advice before you question, and the other's talking about having a lawyer present during questioning, isn't it?
Yes. I'm not a robot. I probably should have read the entire card, but I'm not a robot.
And then you read, if you cannot afford a lawyer, one will be appointed that you left out for you before any questioning if you wish, right?
Again, yes, I must have left that out.
And then, you did testify that you said, do you understand? You didn't say you understand he's right, but you said, do you understand? But he'd already said yep before that, right?
He said, yep, and I said, do you understand? And he said, mm-hmm, and shook his head, yes.
Okay. And then you left out, are you willing to answer some questions, correct?
Is that on the card?
Well, do you not?
I couldn't tell you word for word what's on the card. I could tell you essentially what the card says.
What is that, Mr. Hayes? I'm sorry.
State's Exhibit 3, I'm handing to the detective.
Okay.
Yeah.
Is there an accurate copy?
That's it, and yes, it does say, you have highlighted, are you willing to answer some questions? I did not ask that.
Okay. And do you know why you did not ask that?
No, because I believed that he wanted to talk to me based on our short interaction earlier in the interview where I said that I wanted to talk to him, and he said, that's fine. Actually, I said, I want to talk to you if that's okay, and he said, that's fine.
Were you afraid he was going to say no? I
No,
don't want to
I
talk
wasn't.
to you?
No, I wasn't afraid. I'm just not a robot. I didn't read the card word for word. I read to him his Miranda rights and Miranda warnings.
How many interviews do you think you've done, detective?
Probably hundreds as a detective and probably thousands as a road patrol.
And how many times do you think you've given Miranda rights to suspects before interviewing them?
Well, sometimes I don't read Miranda because they're not in custody and it's not needed. Sometimes I read them from that card, and sometimes I have them signed a written waiver, Miranda warnings. Probably hundreds, if not thousands.
Okay.
I don't know.
Now, you said that you were, well, I'm going to put words in your mouth, but you just talked about he asked for a lawyer, or whether he asked for a lawyer, what he said in regards to getting a lawyer, and that you were trying to clarify that, I think is how you put it.
I said that he muddied the water, and I felt obligated to explore that.
So then, if it wasn't clear to you, why did you say, I understand?
Again, because I'm trying to connect and develop rapport with him, and what I did understand was that he was confused. So I explored it.
Well, you said, I understand, and then you basically asked him, do you have a lawyer? And you went down that path, correct?
I said, I understand, very softly said, I understand.
Okay.
Because I'm trying to continue that rapport that I'm developing with him. But what I really understood was The comments he just made were not clear, and I needed to clarify that.
So you were confused about what he said, but you said, I understand. Is that what you're saying?
I'm saying that I said, I understand, because I am calmly talking to him, developing rapport, but what I really understood was he just muddied the water with what the comments that he just made in the single breath about he really didn't know. His words, I really don't know. If he doesn't know, I don't know what he wants.
Well, I really don't know. You took that to reflect on his request for a lawyer or what he'd been talking about up to the minute before?
No, we were talking about his request to wait for a lawyer. I really don't know. If he doesn't know, I don't know.
So,
Are you buying that this detective was confused about what this defendant wanted and he wasn't sure about the Miranda rights? I'm struggling with that. All right, we'll take a break. We'll have more on the other side. Keep it here on your front row seat to justice.
Tonight, in closing arguments, we're in a verdict watch in the case against Adam Montgomery. The New Hampshire father is accused of murdering his missing 5-year-old daughter, Harmony. Our legal experts break down key moments from the trial as the jury deliberates. Plus, it was a movie set shooting that ended in tragedy. Now the film's armorer is charged with involuntary manslaughter. We'll take you to New Mexico as this trial gets underway.
Closing arguments tonight at 8/7 Central, only on Court TV.
All right, I'm going to take you back to court in just a minute. But right now, I want to bring back in our guests joining us to discuss trial attorney Krista Ramey and LA County Public Defender Philip Dubé. And Philip, I'll start with you. As I said going out to the break, I'm struggling with some of the testimony here by this detective. On the one hand, the state is saying, hey, you know, part of their argument is that, you know, this guy, this defendant, you know, he had some experience with the system. He was comfortable. He was treated well. On the other side, you got a detective who's very experienced, has done thousands of these, and I'm struggling to believe that he didn't know better, not only about the request for the lawyer, but also the Miranda rights.
Of course, and that's why we do these Miranda hearings in front of a judge. A judge can see right through this. It's so transparent, it's not even funny. But the truth be told, unless there is an affirmative invocation, I hate to say it, the cop can use these types of weasel words, as I call them, to try to salvage this confession or whatever statement he gave. That's what they're going to do. And frankly, Michael, if we're honest, with all the other evidence that they have, they don't even really need this statement. So why even compromise your integrity, your believability as a detective on the case? They shouldn't be pulling these types of shenanigans. It's offensive to our system of justice. It's repugnant. But I do agree with you, he knows better. And I find it also disingenuous that he needs his little Miranda card, like a little flash card to read from verbatim, as if it's not indelibly etched in his brain. He must have Mirandized hundreds, if not thousands of people over the years, and to not know Miranda rights strains credulity as well.
I agree. There's not a defense attorney, there's not a prosecutor, detective, police officer who doesn't know that like the back of their hand. You can't tell me that's not the case. So, Krista, to Philip's point, what is the reason? Why are they fighting it? And why is this important to the defense, considering all the other evidence we know is there?
Well, first of all, I think all lawyers know this. I think the three of us probably knew that. For our first year of law school in our criminal procedure class, we had this memorized, right? Yeah, I think that you don't do the sloppy detective work, and I think that you fight it because there is some argument for equivocation. I disagree with Philip to the extent that I think that he thinks it's a lot more loosey-goosey in terms of invoking a right. I think that he did invoke a right, and then the questioning by the detectives is what made it, this detective is what made it more confusing. So that's kind of where I land on this.
All right, fair enough. And you know, again, a judge could certainly go in that direction, as Philip mentioned, without the, you know, the straightforward invocation of the right. So, and this is a high bar. Let's not, sugarcoat it. This is something that generally doesn't happen in the system. All right, guys, let's go back to court now for continued cross-examination of Detective Michael Ross.
Should we get you a lawyer? Why don't you do that?
I don't know why I didn't say that. I explored it the way that I felt was appropriate.
So what do you understand you're supposed to do when a suspect who's in custody clearly asks for a lawyer?
If they clearly ask for a lawyer,
Yeah.
which I've done on other cases, on other homicide cases, they clearly ask for a lawyer, I stop questioning them,
Right.
which I've done before.
You stopped
In this
questioning.
case, he did not clearly say he wanted a lawyer.
But you said that you tried to clarify it with him. That's what you're saying these questions you asked him about, whether he had a lawyer or not, were designed to do.
I did try to explore that and clarify his comments, but he continued playing games with me.
Then you took him playing games with you by, when you asked if he could name a lawyer, he said his dad's name, Keith Doerman, right?
Yes, who's not a lawyer.
Right. And then he said Ruby Franklin, and she's in the CIA.
Yes, who's also not a lawyer,
Did that
and
make
somebody who he knows is not a lawyer.
Now, this was Thursday afternoon, right?
Yes.
In fact, you were involved, and we were waiting for a verdict on another jury case in this very courtroom at that point, right? Do you remember that, the Marvin Armbruster case?
I do remember.
At this point, it's any relevant.
It's irrelevant, so.
Well, if you knew how to get a hold of a lawyer, you knew if you didn't have a lawyer, what are you supposed to do?
If he doesn't have a lawyer,
I mean, you don't think the rule is that he has to name a lawyer or he doesn't get one, do you?
if he says, I want a lawyer, I stop my interview, which I've done on other homicide investigations. That's my obligation. He didn't say that in this case.
So you asked him questions about naming a particular lawyer, and he was not successful in doing that, right?
I was trying to explore those muddy water comments that he had just made to me by asking if there was somebody that I could call.
What about the public defender's office? You knew where I was, right? You knew where we were.
Objection.
That's sustained.
Did you know how to reach anybody in the public defender's office?
Again, objection.
It's sustained. It's asking for speculation. Just
Well, I was asking what he
He's-
knows, Judge.
pretty much answered this question multiple times that he was trying to explore that. And, so I think we can move on.
All right. And I'm sorry, I didn't. You said you let him, or you took him, gave him a bathroom break at some point. What point in the process was that? How far into it?
It was on the latter end, not the front end. It was, I couldn't tell you exactly when it was without referring to the video, but it was towards more than halfway is what I'm trying to say, I believe.
Now, I recall one part of it where he asked for a break. Do you remember that?
Yeah, and there was another part where he begged me to take his cuffs off because he's not going to hurt anybody.
Right.
Yeah.
Okay. You did not take his cuffs off, right?
No, he doesn't control the interview. I do.
Fine. Okay. So he asked for a break. He didn't get the break, did he? Not then.
Well, I don't know exactly what break you're referring to, but no, probably the break that he had was when he went to the restroom with Deputy Greer,
Okay.
somewhere beyond halfway.
And you don't know when that is in time in reference to when he asked for a break?
Not specifically, I'm sorry.
Okay.
All right, that's going to wrap up our coverage for today. Once testimony wrapped up, the judge asked for memos from both sides and said that she would take it under advisement and rule in the coming days.